And the way that our society works out the accommodation between treating people as means and making use of them and respecting their personhood is through a set of more or less conventional moral and legal rules. That is, you take this big ethical theory and you have to accommodate it to reality, you apply some conventional limits. And those limits are very familiar to you. They're in the Constitution and the Fourth, Fifth, and Eighth Amendments. The Fourth Amendment prohibits unreasonable searches and seizures. The Fifth grants due process and prohibits self-incrimination. The Eighth prohibits cruel and unusual punishment. I'm just picking examples. In our common law, familiar to any of the lawyers or students at least who are here, we have self-defense. I can kill you in self-defense. It's a limit on, it's an empowerment of me, it's a limit on your personhood, but it's a very carefully worked out and very circumscribed one. And then we have a whole body of law about necessity, about public necessity, about people destroying somebody else's house to stop a fire from spreading, and so on. We have emergency laws. You can quarantine people and so on without their consent. So we have consensus limits, you might say, on the immunity of personhood. There are things we can do to coerce and control each other. But those consensus limits are absolutely light years from the stuff that Mark described. Here are some examples of the consensus limits that we have. If you want to detain somebody, you've got to take him to a magistrate within 24 hours. If you want to question him in the station house, you have to tell him, this is a limit on coercion, you have to tell him that he doesn't have to answer your questions without a lawyer there. So this is these are profound limits on detention. They're nothing like holding somebody incommunicado for several years and having them sit naked every other day. You can, in one famous case, I'm just talking about what the accommodations between conventional morality and inviolability are. In one famous case, the police, with the doctor's help, pumped the stomach of a defendant to recover the narcotics that he'd swallowed. And what Justice Frankfurter said is, this is too close to the rack and screw to be permitted. Stomach pumping is too close to the rack and screw, but we have cases where they use the rack and screw, basically, that we're talking about. I don't mean literally, but we're getting to real approximations. At the high point right now of your ability to physically control a defendant, you can take a blood sample without his consent. And that by a 5-4 vote of the Supreme Court. So in other words, these are permissions to intrude on inviolability that are pretty far to one end of the spectrum. And the cases that we have of interrogation and detention are pretty much at the other end, or way toward the other end of the spectrum. So we end up with we have a package, in other words, of immunities and power to coerce, and I just tried to describe it. And it's worth noting that that package is designed for emergencies. In other words, it's designed for safety and it's designed for security. In other words, these constitutional amendments are designed to take account of cases where there is an emergency. You've got a crook, you've got you've got a danger, quarantine cases and necessity cases, self-defense cases. So it's not like the common rules that we have now are unrelated to the terrorist threat, in the sense that the terrorist threat is an emergency, it's dangerous and so on. They're designed for situations of danger.